को सुन्नी इत्तेहाद काउंसिल की मखसूस नशस्तों के खिलाफ अपील पर समाअत जारी है, लिए चलेंगे।
During the term of an assembly. 3. A candidate to a seat reserved for women or non-Muslims shall file the nomination papers on the form on or before the last date fixed for filing nomination papers for the election. And the nomination papers shall, as nearly as possible, be scrutinized in the same manner as nomination papers of candidates on general seats are scrutinized under section 62. 4. If at any time the party list is exhausted, the political party may submit a name for any vacancy for which may occur thereafter, and the provisions of subsections 1, 2 and 3 shall as nearly as possible apply to fill such vacancy. 5. Where a seat reserved for women or non-Muslims in an assembly falls vacant as a result of death, resignation or disqualification of a member, it shall be filled in by the next person in order of precedence from the party's list of candidates submitted to the Commission under subsection 1. 7. A candidate contesting election on a seat reserved for women or non-Muslims shall, along with his nomination papers and its annexures, submit to the returning officer appointed by the Commission in this behalf a copy of the party's list of candidates, political party for such seats, declaration and statement in support of the nomination, and proof of deposit of fee required for filing nomination papers. 8. Where there is an equality of share on reserved seats between two or more political parties, the returning officer shall declare the returned candidate by drawing of lots. Now, my lord, may I return to...
it, or did you skip 6?
6 आपने नहीं पढ़ा.
I was thinking I had, my lord, in my, I'll read it, I beg your pardon, I suspected I had missed it. Before notifying the name of the next person in order of priority from the party list, such person shall submit a declaration on oath that since the filing of his nomination paper, he has not become subject to any disqualification contained in Article 63.
Then sir, kindly read explanation to Rule 94 as well, don't skip that.
Okay, sir.
Explanation to Rule 94 of the Rules of 2017, Chapter 6. Go to the direct explanation attached with Rule 94.
For the purposes of this rule, the expression political party means a political party to which a symbol has been allocated by the Commission.
Yes.
Sir, now may I come back to E, and I've read everything, so now I will make my humble...
Is this explanation is not in conflict with the definition provided in section 2 of the Act?
I beg your pardon, sir, I didn't hear that.
क्या ये जो explanation है, ये Act में section 2 में दिए हुए party definition के against नहीं?
May I answer this after I've made my... I just want to give... मैंने अभी एक section पढ़ा है बगैर किसी उसके...
उन्होंने कहा ठीक है बाद में कर.
Oh, grateful sir.
देखा note कर दे sir.
मध्यम आवाजों को भी तवज्जो दीजिए.
जरूर sir. Sir, I've been endeavoring to answer at least. I don't know what the score is, but anyway. Sir, E. Sir, E.
E तो पढ़ लिया.
जी, अब मैं अपने submissions दे रहा हूँ. Paragraph E is followed by a proviso. In my humble submission, it is a classic proviso. The classic function of a proviso is to either include or exclude something which appears to, or on a reading of the principal clause, is excluded or included. So it gives a carve out in a positive or a negative sense. That's exactly what it does. This one is my humble submission, number 1. Number 2, just for argument's sake, my lords, please now again read the principal clause with me, and for this moment only assume there is no proviso. So we get the sense of the principal clause, and then we'll figure out what the carve out is, because this is what is happening. So my lord, I read E as if there is no proviso. The members to the seats reserved for non-Muslims shall be elected in accordance with law through proportional representation system of political parties' lists of candidates on the basis of total number of general seats won by each political party in the National Assembly. My respectful submission is that just from the principal clause alone, right now I'm pretending the proviso doesn't exist, and that the expressions secure and won are clearly intended to be used interchangeably. I read E because it's just clearer, but my humble submission is that the expression secure in D also means won. To my mind, my lord, one indicates winning a general seat by the political party which is the claimant of reserve seats on its own steam, to which something is to be added in the proviso. The principal clause on reading as if the proviso doesn't exist would bar everything else, and if it wasn't there, then reserve seats would be allotted only to political parties which participated in the election and were present in the relevant assembly. There are 5 relevant assemblies, the National Assembly and the 4 provincial assemblies. So wherever you claim a reserve seat, you should have presence. You should have won a seat. The appellant does not meet this condition, admittedly. Now, my lords, we read it again as a proviso, as a principal clause with a proviso, and the proviso is doing the carve-out. It is on its reading of its own. Independents have nothing to do with this political party because their political party is entitled to reserve seats based on whatever it has won on its own steam. Now we come to the proviso, which creates a very special exception, as observed by my Lord Mr. Justice Muni also, by using these words, provided that for the purposes of this paragraph. This means only for this paragraph. We can't even take these principles and kind of extrapolate or import them into anything else. For the purposes of this paragraph only. The Constitution creates an exception and says, if an independent joins you in 3 days, you already have won something, you can add those independents to whatever you won. If an independent joins you on the 4th day and you've won something, tough luck. If 300 independents join you on the 4th day, no reserve seats for you. Those individuals will not be taken into the math for calculating the share of reserve seats. It's very, very clear. This, my lords, is my humble, plain reading of the constitutional text. It does not require a scholarly, creative interpretation because, to my mind, there is no anomaly or doubt in it so as to move towards some more advanced constitutional gymnastics. It does not ask for that, and whether we like it or not, this is what it says. If it is a bitter pill to swallow, it's a bitter pill to swallow. But it does not give room for these novel interpretations advanced on behalf of the appellant. Secondly, the appellant's interpretation requires reading in and implying into 51D, E, and 106. And at the same time, I will now, my lord, count how many subsections of section 104 in my humble submission have to be completely ignored as if they don't exist, read them down, pretend they don't apply. There's two formulations given. One is read it down, for which